you very much to everyone, and welcome to this roundtable on dispute resolution and Web 3.0, decentralized dispute resolution and Web 3.0. I'm very glad to be chairing this panel today with great speakers and panelists. So the way we're going to work, I'm going to introduce very briefly each of the speakers and the methodology of this roundtable. Then we're going to move on with the roundtable discussion, and finally we will open up for questions. So let me first give you a very short introduction to the topic. So we're going to be talking about decentralized dispute resolution, decentralized justice, and Web 3.0. So as you certainly know, the ACT project, and especially the group I'm leading on smart contracts and regulatory technologies, has been involved in working on smart contracts and how these smart contracts connect and can be sort of the application layer of the blockchain infrastructure. And part of the work we've been doing is on looking into preventing conflicts, but also into the possibility of using the technology to resolve conflicts. And in the panel we have today, we're going to be digging into the origins of the blockchain technology and how these origins may impact actually the applications today, the new models of trust that blockchain bring into the administration of justice, or at least a dispute resolution, more generally speaking. We're also going to be talking about the different stakeholders that participate and how we can build up solutions that are relying on the new potential that technology brings, but also new models of reasoning like game theory. So this is our menu for today. And I'm very glad to host first introducing, as they will be speaking, Federico. So Federico, thank you for joining today. Federico is a legal innovator, public speaker, and technologist. He graduated in economics and philosophy and spent his career working in startups and online media. He received his PhD from IAE Business School, which is a leading business school in Argentina, and his work focused on deliberative democracy and collective decision-making. He's, of course, globally known as the co-founder of Kleros and current CEO. And Kleros is a decentralized justice system that uses blockchain and game theory for dispute resolution. We will be, of course, talking about it today. He actually chairs and delivers the first blockchain Coursera course in Spanish, La Disrupción de Blockchain y el Abogado del Futuro, that focus on the digital transformation of the legal industry. Thank you, Federico, for joining us today. We also have with us Primavera de Filippi. Primavera is a director of research at the National Center of Scientific Research, CNRS in France. She's also an associate to the Berkman Klein Center for Internet and Society at Harvard University and a visiting fellow of the Robert Schuman Center for Advanced Studies, the European University Institute. She was a founding member of the Global Future Council on Blockchain Technologies at the World Economic Forum and a co-founder of the Internet Governance Forum Dynamic Coalition on Blockchain Technology. She's the author of the famous book, Blockchain and the Law, published in 2018. Thank you, Primavera, for joining us today. Then I'm also happy to welcome Florence Guillaume. Florence is a full professor of civil and private international law at the Faculty of Law of the University of Neuchâtel in Switzerland and founder of the LexTech Institute, which is an academic center dedicated to the research and training in digital economies. Florence has been the Dean of Faculty previously and was also a member of the Council of the University. Before entering into academics, she practiced law at the Geneva Bar and the Zurich Bar, and she was also deputy to the head of the Private International Law Department at the Swiss Federal Ministry of Justice. Thank you, Florence, as well for joining us today. And Karen, who will be our discussant after the roundtable session. Karen is an academic. She just received her PhD. Congratulations, Karen, again. She's a scholar and attorney, and her work focuses on dispute resolution with an emphasis on technologies and the impact on law and society. She's based between California and Dubai, and she's joining us today from Dubai. Thanks, Karen, for joining us as well. So just to let everyone know about the methodology of this roundtable discussion, the panelists were provided with some questions prior to this session, and each of them provided comments to the 2 questions that was given to them. These questions were read and shared among the other members of the panel, and we're going to start by a discussion, engaging directly in the discussion with the answers. So one of the panel members will summarize the question and the position of the person that answered the question, and will immediately engage with that answer. After that, those are 5 to 7 minutes. The person that provided the answer will have 1 to 2 minutes to provide comments or a rebuttal. And we will move all the way down. We have 6 questions in total. After the questions have been addressed and the comments have been provided by the discussants, Karen will give us a general comment on the discussion and will cherry pick from the discussion the most interesting things on which she wants to comment. After that, we're gonna open up for questions from the audience. So that having been said, our first panel member to speak will be Federico, and Federico will be commenting on Primavera's first question. Federico, the floor is yours.
Thank you very much, David. What a responsibility to comment on, discuss with Primavera, you know. So the question I was assigned was, what are the key technological characteristics of Web3 and to what extent are they relevant to this solution? So the answer states that the key characteristics are decentralization, verifiability, and tamper resistant. Decentralization means that there is no central authority in charge of managing the network, which makes it virtually impossible for anyone to influence or terminate it in a unilateral way. Verifiability means that all operations made on a blockchain are recorded and timestamped, which creates a perfect audit trail of transactions to prevent fraud and ensure accuracy. And then there is resistance, which is important for ensuring that the process is tamper-proof and that all data is stored on the blockchain cannot be manipulated, right? So this has 2 important elements for this solution. First is it can be used to provide evidence that it's stamped on the blockchain with full auditability and transparency. And then this can be used to build a resolution system where the logic for decision making is going to be followed strictly as it's put into the code, and no one can tamper with that. So this was very influential when I was starting thinking about Kleros. My background, I'm from Argentina, and I'm not a lawyer, and my background comes more from economics and philosophy and political science. And what I was more like concerned about when I started was this idea of or this reality of poor countries having like very weak institutions where there was like lots of corruption, lots of arbitrary decisions, and this was very evident in the justice system. So, and this was an element that well, it denied equality of opportunity to people who did not have access to you know the system. So it was about this high level of corruption, not giving people inclusion, right? So when I started working on blockchain, what for me was mind-blowing is the idea that it could produce some effect that was kind of similar to the rule of law. You know, a blockchain is going to work exactly as it's coded, and smart contracts that are deployed in that blockchain are going to, deliver the process exactly as it's coded, and everyone can verify that. So taking process of justice out of this black box and putting this on the crystal box where everyone can see how it works, and this is a fundamental aspect for people to trust how this is working. And for me, this was a way to give countries like Argentina or any other emerging economies something that is similar to the rule of law that you guys have in Canada or in Switzerland or France, or developed economies. So Argentina was not going to do this because of judicial reform. So it's like that the Buckminster Fuller quote, you don't change the world fighting the old reality, you just build something that makes it obsolete. So to me, what the potential of mixing blockchain and dispute resolution systems was a way to make obsolete old systems. Of course, no one is expecting Kleros to be used in criminal or whatever, but for like lots of smaller transactions where lots of Argentinian people could work by providing services to other parts of the world. So this of blockchain and rule of law and Web3 was for me a killer feature, and that's what in my case put me on that track and made me want to work into building institutions for the digital age. I don't know if that's a great answer from me, but what Primavera thinks.
Thank you, Federico. Primavera, do you want to comment on that?
Yeah, sure. I just I'm gonna add a few words. Yeah, so for me, like to answer this question, perhaps in more details, I think it's all a question of like to which extent can we leverage trust and or confidence, and what are the different tools that we have in order to either increase trust or increase confidence. And I think with regard to the first application, which I think is pretty much like uncontroversial, which is like using blockchain-based transactions or using data recorded on the blockchain, whether in clear or as a hash, as a form of evidence, definitely create some strong provability. It creates like a very secure and tamper-proof audit trail, because you know that those information that have been recorded could not have been forged. You cannot pretend to have made a transaction that is not recorded on the blockchain, or vice versa. You cannot pretend not to have done a transaction which actually appear on the blockchain, but also the possibility of recording data, recording most importantly like hashes of data. So you can actually create proofs without actually disclosing any information at the time. But because you have recorded the information through the hash, you are pretty much committing that if you desire to do so, you're revealing some information. There is a proof that this information has not been manipulated from the time in which it had been hashed. And so this creates like a stronger degree of provability, which might reduce the need for oversight, auditing, and so forth. And so in this sense, we can say that blockchain technologies are increasing the confidence and therefore removing or reducing the need for trust into the involved actors. Whereas in the second aspect, so the actual use of blockchain technology for alternative dispute resolution system, it's interesting because actually, as Federico said, both of them require trust. None of them can be held to be trustless. Either you have to trust the judge, you have to trust the court system, you have to trust the enforcement authority, and so forth, or you have to trust the alternative dispute resolution system, which requires trusting that in the case of Kleros or whatever the mechanism we're looking at, you need to trust that the design, the technological design, that the economic game theoretical incentives are trustworthy, are actually valid. So you still need to trust the system. And instead of having to trust one judge, which could be corrupted, of course, in this sense, you're distributing the trust. There is still trust because there are still people that could be corrupted, but by distributing it into a variety of randomly selected people, this trust is not dependent on only one single actor. But of course, there is it's hard to say like which one is more trustworthy. And I think it mostly depends, of course, on the cases, on the matter that is at stake. In cases in which there is like a strong stake and therefore potentially a strong incentive to try and corrupt the system. It's really a matter of like, where do we choose to put more of our trust? Do we trust better a judge and the traditional legal system and the oversight that comes with it? Or do we trust more this more decentralized and distributed system of trust that mostly rely on economic incentives? But basically what I'm saying with this is like, while for evidence-based, I think we can clearly say that blockchain technology definitely increase confidence. In the case of dispute resolution system, it's not really a matter of confidence, it's just a matter of like, what type of trust do we prefer to engage with?
Fantastic. Thank you, Primavera. And that actually connects us very well with the second question for the panel, which is now the turn of Florence to comment on Federico's question number 1, which was precisely about what are the characteristics of dispute resolution in the era of Web 3.0, and how does it change of having blockchain as a support or as a system driving the dispute resolution. So Florence, I'll give you the floor.
Yes, thank you, David. Well, I know that this was the question, but reading what Federico put in his answers, I had another question for him, and Federico, please excuse me, but it's a new question. So as the co-founder of the one and only blockchain-based dispute resolution system that is using actually decentralized arbitration, I was wondering if you could explain a bit more what is your vision of the use of blockchain to render justice in the Web3? Because I think it's a very important question, how you are going to move from the actual blockchain resolution systems to the Web3 resolution systems that could be implemented in this new kind of interactions between people. And in your comments on the questions that you were assigned, you have sketched a new conception of justice. You have already spoken about it in a few minutes ago, but it's very important that you explain this new conception of justice that you have in your vision now, because I think it will be very important in the future. And you said in your answers that new virtual worlds need new tools to render justice. And you explained that the dispute will arise in Web3 across jurisdictional boundaries between anonymous people that only interact through avatars. And you also said that for those kinds of disputes, and I quote you, the native jurisdiction is a metaverse. And that's where I jumped, I must say, because as a professor of private international law, I couldn't help but jump on this comment. The native jurisdiction is the metaverse. And I must confess that I agree with you that there is a jurisdiction of the metaverse. And there is a jurisdiction of the blockchain too. But so far, I must confess also that there are very few of my colleagues that would agree on this point, which is still important to keep in mind. So if we can say that there is a jurisdiction in the metaverse, as we could say that there is a jurisdiction in the blockchain right now, what do you think would be the applicable law in the metaverse jurisdiction? Well, you know, in private international law, there is always a question of jurisdiction and then of applicable law. So this is the question. What would be the applicable law in the metaverse jurisdiction? Would it be the law defined by one or more states, and which states? Or would it be the law defined by the platform adopting its own rules, or simply by the computer code? Or does this question, or is this question of the applicable law actually makes no sense at all? So that's my first question to you, Federico. What would be in your vision of the future of dispute resolution, the future in the metaverse, the applicable law, if there is one, or do you think that this is a question that makes absolutely no sense at all?
I mean, I think that this is a moment to think about the first principles of things. So, and what is the origins of law? In the end, it's like make some rules that will help communities well live together and resolve their conflicts in contexts where like public goods and their free riding opportunities and etc. So the metaverse is a bit of a fluffy concept, and it's ambiguous. But how I imagine this is, you will have blockchains, and in blockchains you can build these things called DAOs, these cooperatives of people who share some like interest. Some of them in decentralized finance, others in NFTs, others in decentralized gaming or whatever. And these are communities that, well, they start making rules on how they want to interact with each other. And so these online communities, they like just start becoming like, well, I mean, jurisdictions in the end. So if there is a dispute between two members of the DeFi DAO, these people, they don't know who they are. I mean, in the real world, if you want, they would define the real world, the world they share online, because they spend more time in that reality than in the mid world. But so, and they only know each other through avatars. So I'm sure you have all seen, Ready Player One, and these people just interacted through, their avatars. They didn't know who they were outside. So these rules that they start making through a governance process, including voting on what rules they want, or through customs and practice and well, interactions, some patterns of behavior start to emerge, and that can, if some dispute arises, that again can become the law of the land or of the metaverse. So it's very hard for one to imagine, or for me at least, how you could solve a claim between two avatars from who knows where they are, because they are anonymous. They are, they could be in any geographical place, and the claim is entirely about the ownership of some digital sword of a game of League of Legends or whatever. What is the jurisdiction for this, and where do you? And I'm meaning this from a practical perspective. Where do you go present a claim? You go to court, you go to the ICC in Paris. You go where if you have some problem with some avatar in one of these DAO. It seems to me very hard to think how this could be resolved in a way which is not through a native system of resolution in a metaverse, right? So the thing is that this already exists, but we don't see it. When you have a problem with someone on Twitter and there is some moderator from the company that can, delete comments, or they can ban a user, they already are like kind of judges, if you want, in this metaverse decision called Twitter. But we don't see it like we see that the company. We don't see it like a justice procedure, but it's kind of a justice procedure because they are resolving a claim, and this resolution will have some very profound impact in the losing party, because if they ban you from Twitter, well, then you might lose all of your following, and that might be very important for you. So we are not seeing that we are already living in these jurisdictions. The difference is that Web3 is going to be decentralized and with user input in how the rules are made and how the claims are resolved, which is not the case in the Web2 platform. So that was the spirit of what I was thinking when I was answering that question.
Yes, thank you, Federico. I have a second question for you. Going back to the question initially that was assigned to you, what will be, in your opinion, the key characteristics of dispute resolution in the area of Web3? Can we foresee that different modes of dispute resolution will be developed with different technologies according to the needs of the users?
Yeah, so my vision of this, and this is something that can change in the future because it's work in progress as we're building this as we speak, is that there's going to be like a threefold division of the technologies for resolving claims. So for more, let's say, objective or simple claims, I think that they are going to be solved in a fully automated way, like some machine learning algorithm, like the robot judge, if you want. It's going to be probably used for similar situations where because it's basically cheaper, you know, if you can do it in a fully automated way, just do it that way. Then other type of claims that are still like low value, but still way too complex to be resolved by a machine in an automated way, which involve like interpretations of intentions of agents, well, ambiguity in what was agreed, because there was a discussion on some telegram that is presented as evidence. It's hard for a machine to understand what was the intention of party. So I think that this type of still small claims and quite simple situations, but with like high human element, this is where Kleros or other decentralized justice, like, and then there will be other type of claims that are more complex in the sense of having multiple parties or having the need of legal interpretation, legal reasoning. That's going to be probably resolved by like more traditional, if you want, ODR systems. Traditional in the sense of having a hearing by an arbitrator that's going to listen to the parties. Of course, it's going to be online, it's going to be on Zoom with the blockchain. It's going to look a bit like what it looks now, like a mini trial over Zoom, if you want. Why the decentralized justice approach has this idea of different mechanism design and completely different game theoretical element, incentives and all that. So I think that that's going to be this division where each type of tool is going to be used for different problems, because they are suited for different others. For example, the Kleros approach, and this a bit draws on what Primavera said, maybe it's harder by people to trust it in very high level claims involving millions of dollars, when people expect a process that is done as they are used to it, right? And others, you know, for other type of claims, which I don't know, content moderation, a decentralized Web3 network, we don't have a very well-formed expectation of how one of these claims should be resolved, because this is not resolved by arbitration now, right? So we could be more, we could accept using game theoretical elements because, it's a different use case. That's where I am at this now. I can change in the future my vision, but that's what I think at the moment.
Thank you very much, Federico.
Thank you, Florence, and thank you, Federico. Some great elements there. We could pick on many of these, and we're actually coming to some of them in the questions and hopefully in the discussion as well. Primavera, it's your turn now to discuss Florence's first question, which basically I think Federico already touched on it somehow on his sort of inspiration to work and to found Kleros. And that question is, to what extent are the premises of Web 3.0, dispute resolution, blockchain-based, decentralized, tokenized, compatible with the premises of democracy and the rule of law of political systems? So you want to comment, you want to share with us the answer of Florence and your comments on that?
Yeah, so I'm going to summarize a little bit the answer of Florence. So Florence described how justice is a prerogative of the nation state, and that the sovereign can exercise justice over the persons and the properties that are in their own jurisdiction. And then we have alternative dispute resolution system or online dispute resolution system, which some of them are accepted as a method of doing justice by private means, but only provided that they comply with specific legal rules. And so in the case in which there is compliance, then we have like arbitral awards that are given legal effect and therefore also become enforceable by state authorities, but only provided that they actually respect every single one of the rules that have been established by the sovereign in that jurisdiction. And one important of those legal rules is the right to a fair trial, which means that everyone should have the right to be heard by a competent, independent, and impartial tribunal. And so in the context of blockchain-based dispute resolution system, if they do respect those legal rules, then any decision that is taken by those systems will also be enforced or enforceable by the authorities. Now, the problem is that this actually makes sense to the extent that the decision can be enforced in the context of physical assets that do not actually exist on the blockchain, whereas if the decision involves seizing or somehow transferring or reverting a transaction that happens on the blockchain, then traditional state authorities will not have the ability to enforce those decisions, although maybe the blockchain-based system could, right? And so this means that a blockchain-based dispute resolution system can enforce specific decisions which are related to on-chain assets, even though the dispute resolution system does not actually comply with the legal rules that are established as to give legal effect to those decisions. And so the conclusion that is provided by Florence is that there is some kind of complementarity between government authority, which can enforce off-chain transactions and assets, whereas blockchain-based system can only enforce the on-chain assets. And so as part of my own commentary, I would say that perhaps the interesting question is not to ask whether the two are compatible, but rather it's about understanding whether it is necessary to have both, in the sense that if we have a blockchain-based dispute resolution system, which can only enforce decisions with regard to on-chain assets, and if we have governmental authorities which can only enforce decisions related to off-chain assets, then there is an actual need for both traditional court or dispute resolution system and blockchain-based dispute resolution system in order to ensure that all decisions can be properly enforced, both on-chain and off-chain. Now, the interesting thing is also that the two can be potentially integrated with one another, right? Because even though blockchain-based dispute resolution systems are not subject to the same legal rules as traditional dispute resolution system, because they can enforce their own decision on their own, so they don't need to comply with those rules in order to benefit from the state enforcement. They can, if they do actually follow those rules, they can also be enforced by governmental authority. And that means that the scope of a blockchain-based dispute resolution system can also extend into the physical world. And so this suggests that there is a very strong type of complementarity and a potential symbiotic relationship between traditional dispute resolution system or court systems and blockchain-based dispute resolution system, where each one are capable to enforce the decision in their own respective domain, but also they are able to enforce each other decisions in a domain that is actually not accessible by the respective by the other type of dispute resolution. And so in the same case in which we could have blockchain-based dispute resolution system that can be enforced with respect to the decision that needs a physical enforcement branch, if they comply with the specific legal requirement, we could also have the opposite, which is we could have legal decision in a traditional court or alternative dispute resolution system that could be also enforced by a blockchain system with regard to on-chain assets if they comply with the technical requirements of the blockchain. And that means that we could imagine some blockchain-based dispute resolution system that actually takes as oracles a particular decision that is made by a court or an actual existing and physical alternative dispute resolution system in order to ensure that the decision can be enforced off-chain through the traditional state authority and also on-chain by the blockchain-based system.
Thank you, Primavera. Florence, do you want to comment on it? Do you have any reaction?
Yes, I could comment just a few words because Primavera resumed perfectly well what I said, and even better than how I said it. I think I do agree with Primavera, and that's what I put in my answers, that a decision rendered by a blockchain-based dispute resolution system could be enforced on physical assets if and only if it respects fundamental procedural rights of the parties, and in particular the right to a fair trial. I don't think that the systems that are in operation now, like Kleros, to mention one of these systems and the main one, is able right now to provide such kind of decisions. But I think they are working on it, and one day they are going to provide decisions that could be considered as respecting the right to a fair trial. That's the first point. The second point, the enforcement of decisions rendered by a state court on crypto assets. Well, I know that there are some proceedings that are now in course. So there are some proceedings in some countries, and there are judges that are trying to render decisions on crypto assets, and I'm sure they are going to find solutions to enforce them on crypto assets and on the blockchain, even if it's tamper-proofed. Tamper resistant, sorry. But it still is difficult to enforce these decisions if we don't know the name of the parties, if we don't know the identity of the parties. And in any case, we couldn't make any procedure against persons that we don't know because they are totally anonymous or pseudonymous. So that could be one of the problems. And if we don't have any means to exert some kind of pressure on persons, on physical persons to execute the decision on the blockchain, I think it will be totally impossible to obtain such a decision on crypto assets without the cooperation of the parties. So what I just wanted to add is that if we want to create a bridge, some kind of a bridge between the two justice systems, on one side, the state justice system, on the other side, the blockchain-based justice system. If we want to make a bridge between these two justice systems, we have to keep in mind that the bridge cannot go only in one direction. So it will go in both directions. And this means that if a decentralized justice system wants to have an effect in the real world, it will have to accept to lose some of its independence from the states. This means that states are going to create some kind of a legal framework, like for arbitration, and they will exert some kind of control over the system, or at least exert some kind of oversight over the system. And that's a question that we have to answer. Do we want states to have a control or to have an oversight over the system that we are going to put in the metaverse, for example, or that we have already in the blockchain?
Thank you, Florence. And before moving to the next round of questions, maybe two things that I would like to highlight at this stage. I think Federico raised something very interesting that I would translate it into the natural forum for Web.3 dispute resolution, and that it was also commented by Florence. And I think when Federico made the comments on user input and sort of the different types of dispute and different way in which they emerge in Web 3.0, may also lead us to think in a different way, the dispute resolution systems, because now we are sort of attaching it either to, as we said, physical assets of Web 2.0, which are indeed working under sort of a different technological model. So that's the first thing. And the second, maybe, I don't know, a clarification, but I'm just throwing it for discussion if anyone wants to pick on it. And it is not because there is a blockchain supported or blockchain dispute resolution system that it can address on-chain disputes and solve them, right? There is still a technical and technological infrastructure that has to be built in many terms, for instance, interoperability for an asset or a token that operates in one blockchain, that if Kleros, let's put it like that, because we are today with Federico, solves a dispute, actually that token will be able to be returned to its original user or transferred to another user. I mean, there is a big step from one to the other. I just wanted to put that, and this is just reconnects to the idea that we are probably still thinking somehow these conflicts in a sort of Web 2.0 framework, and maybe they will present themselves in a different way in Web 3.0. So just now, giving the opportunity to Florence, you were the last one to speak, Florence, but it's your turn to comment on Primavera's second question. So I get back to you.
Thank you, David. So Primavera, you discuss in your book, Blockchain and the Law, the origins and ties of the blockchain with the crypto-anarchist movement. Now we can see that many actors of the financial sector seem to distrust blockchain because of its anarchist origins. However, many claim that recent developments, such as, for instance, new tech stacks or Ethereum virtual machine, are mainstreaming the blockchain and making it suitable to traditional actors like banks and other financial intermediaries. In your comments on this topic, you pointed out that there is a difference between the crypto-anarchist ideology, which is at the root of the blockchain, and in particular Bitcoin, and the blockchain technology itself. It is clear that there are two different things. You also said that blockchain is becoming more and more mainstream with the advent of new tech stacks and applications. Indeed, those new tools help blockchain technology to be adopted by a wide range of traditional and non-traditional actors. So I do agree with you that the development of applications that run on top of the blockchain, like Lightning Network and RGB protocol, and so on, has the benefit of facilitating the democratization of the use of blockchain. It is not only an important technological progress, but also a natural development of a technology that is at the beginning of its evolution. But the other side of the coin is that there is a progressive loss of the original identity of the blockchain ecosystem as a result of states and central authorities taking over control. So do you think that this is troublesome?
Yeah, I guess the answer is not at all. I think that a technology becomes a successful technology when different actors with very different ideology all see a value in that technology. And I think you can actually see a lot of different waves of adoption of blockchain technology. The first one where indeed the crypto anarchists, cypherpunk, crypto libertarian, etc., that saw this potential in this technology because of pseudonymity, because of decentralization and disintermediation. And then we have a whole new field of adoption, which is mostly the entrepreneur that are leveraging technology for doing like fundraising, for just like creating innovative fintech and a variety of different technology, which are perhaps still early libertarian ideology, but actually more like actually business oriented people. And then at the same time, you also have like a whole different crew of people that are like more like the commoners, which all of a sudden discover that DAOs could enable more distributed and common-based and participatory action, and that are also engaging with blockchain technology, with an ideology that is actually quite different from the crypto-libertarian, because it's actually more of a common-based thing. And then all of a sudden you have like the financial system, the traditional institution that were first making fun of the technology and then afraid of the technology, and now realize actually these can be very useful for regulatory compliance, this can be really useful for transparency and accountability, and are therefore adopting this technology as well, also because it's providing a new tool for them to engage into this new market of financial products. And then we also have governments that are entering the space and are actually trying to explore the extent to which blockchain technology can help them in order to, again, provide better transparency, accountability, etc. And so to me, this is actually, it will be a problem if the fact that other people than the cypherpunks are actually seeing a value in the blockchain. Actually, the technology needs to be able, as a technology, to be able to serve the interests of a large variety of actors. And the more actors manage to understand the value that the technology can provide to them, then the better it is for its adoption.
Thank you, Primavera. Primavera, if you agree, and Federico as well, I would like to shift you so you come now and you comment on Federico's question, so we make sure we hear your comments on Federico's before you have to leave us. Is that fine for both of you? Okay. Yes. So Primavera, back to you to comment on Federico's second question.
Okay, so Federico's second question was, the Kleros dispute resolution offer relies on game theory to adjudicate legal disputes. Is game theory a replacement or a complement to legal reasoning, and how? And so Federico proposed as an answer that game theory can be seen as a complement to legal reasoning, but that probably game theory cannot be used to resolve complex claims, such as those that are, for instance, the domain of international arbitration, but instead they can be very useful for simpler claims where game theory provide a more efficient, meaning cheaper and faster than traditional methods. And so the main claim that Federico makes is that systems like Kleros based on game theory are good for small consumer arbitration claims, such as the one that we might encounter in e-commerce, but will not be able to replace law professional for complex claims. And so with regard to my commentary to that, I think that we can actually, I will go a little bit further perhaps and say that we could actually say that it is not just a complement, it is a replacement in the sense that it will actually likely take over some of the simpler claims that will traditionally be handled by law professionals. And if to the extent that everything can be enforced on-chain, meaning that it is a claim about on-chain assets and transactions, then it will not need the support of traditional enforcement authority. And it also means that it doesn't need to comply with the legal rules that would be required in order to benefit from this enforcement. But at the same time, I will qualify this stronger claim by saying that this also means, of course, that those clauses will not be adjudicated based on legal reasoning, but rather on those pure game theoretical rules, trying to identify what is the Schelling point and like driven by economic incentive to do so. And that makes it unlikely to be given legal effect because they do not comply with the requirement of a fair trial. And so, well, even though there is a potential replacement, that replacement cannot be held to be absolute because even if the blockchain were capable to enforce such a decision, then because it doesn't have legal effect, then a person that feels damaged with the decision of the blockchain dispute resolution system could still decide to bring a legal proceeding, and the judge might actually decide that the decision of the blockchain-based system is not fair, is not the right decision, and therefore try to undo or revert the blockchain enacted solution, potentially by going after a person's physical assets, because obviously it is not possible to go after the on-chain assets. And so that means that it is a replacement, it's not a perfect replacement because there is no guarantee that you are safe from the grasp of the law, because there is always a possibility of appealing or relying on legal proceeding. And then on the other hand, while we could consider that there is this non-perfect replacement for small claim, I will say that blockchain dispute resolution system is neither a replacement nor a complement with regard to complex claims, and especially those that involve off-chain transactions, because of course those will always need to be resolved through traditional means of arbitration and legal reasoning. And then a final comment with regard to the more efficient. So we usually say that things can be cheaper, faster, or better, and you need to pick two. And so blockchain dispute resolution system, I think in many cases clearly cheaper and faster, but to which extent can it actually be said to be better, right? Can the blockchain actually break this trilemma? Because the game theory mechanisms that are used, is that actually the way in which we want specific adjudication to be based on? and are they actually going to lead to a better outcome than legal reasoning? And there is also the question, of course, to which extent can those systems can be manipulated by economic interest, and to which extent is it possible to cheat, for instance, by trying to change the Schelling point. And to this, I think that the better is contextual. I don't think there is like, I think faster and cheaper could be generalized, but the better is not necessarily so, but it depends on the context in which it is used. And I think it can only be better in the context of those small claims in which there is not enough stake to try and corrupt the system by other means, but they most likely won't be better, even though they can still be cheaper and faster in the context of claim in which there is such a stake that a variety of actors might actually try to engage into affecting the Schelling point.
Federico, we still have Primavera with us for like 5 minutes. So you want to comment on her answer?
I think that she's, spot on. I agree with that. I mean, I think that this is a moment where you want to unpack what is decentralized justice, because it depends a lot on what you compare it with. So if you compare decentralized justice with how an e-commerce claim is handled in an e-commerce platform, it's probably not faster, so not cheaper now, but surely better. So, but if you compare it with international arbitration for a $1 billion claim on oil and gas, I mean, yeah, it's not better, right? Because it works quite differently, and probably, I think a big thing here is that it's not very easy to define what are the metrics or what are the criteria by which we should judge the resolution system. Like what should that process look like to say that a procedure is done the right way? Yeah, some ideas coming from the New York Convention and all that, but I mean, it's not easy to define what counts as a better resolution system than others. So that's one thing, and that's if you're interested in this, you will of course like the Richard Posner paper on what do justice is optimized, which is about the incentives in the traditional legal system. I mean, because we also tend to idealize how traditional arbitration works, as if like Kleros is tainted by economic incentives, and the traditional systems are not. I mean, they are made by pure people responding to the best interest and in fairness. So there is a lot of discussion there to do, and that Richard Posner paper is also. Then there is another aspect, which is about what happens if some losing party in let's say Kleros trial is angry and they want to go to court and overturn the decision. So this is about what was discussed before, about the bridging between the on-chain, legal order and the off-chain legal order, if you want, and how this works. So there is a lot to, learn there, but we already have a case where a judge in Mexico accepted a ruling made by Kleros as legally binding in the Mexican jurisdiction in a landlord and tenant claim. This was a strategic litigation case that was done by a Kleros fellow, a community member from our community. And he wanted to answer that question, because before that, there were like people arguing, writing papers. Yeah, Kleros complies with the New York Convention, or Kleros complies. So, but he wanted to see, okay, what happens if there is an actual claim resolved by Kleros and this goes to a judge? Will the judge accept this or not? So what he did is write a very clever arbitration clause that he, as an expert in arbitration in Mexico, thought would work on that setting. So what happened is that the contract between the landlord and tenant designated this arbitrator called Mauricio, who is a professional arbitrator from Mexico, as the arbitrator for the case, and instructed him to use Kleros as a tool for solving the claim should that claim arise. So what happened was the claim arose because the landlord and the tenant had not paid rent. So the landlord sends an email to the arbitrator. So, Mr. Arbitrator, you have this problem. You are the arbitrator. You need to solve this. So, and look, this is the contract, and this is we didn't get the payment from the tenant. So the tenant answered by email to the arbitrator, look, this is not true. This is the bill where it's signed by the landlord when they accept I pay the rent. So the arbitrator took all this information and went to an interface we had Kleros you can use to load cases into the system. So he loaded the case and he put, okay, Mr. A says this, and B rebuttal is this. And then it goes to Kleros, the jurors evaluate the evidence, and they produce a decision. And then the arbitrator takes this decision to a judge to tell the judge, please go enforce this, because this is an off-chain matter. You need the police to go to evict someone from a house. That's not an on-chain problem. So, and the judge accepted the claim because the contract said that the arbitrator was this guy, and this guy had to use that method. The guy was the arbitrator, the method was used. So the judge accepted the ruling and had it enforced. So that was a clever way in which this bridge between the off-chain and the on-chain legal orders was done. It worked. The judge accepted the claim. And now there's people trying to do the similar experiments in Spain, there's people in Uruguay, there's people in Guatemala, there's people in Honduras. All those are people who, want to learn about this and want to battle test, decentralized justice under the situation of different jurisdictions. They're trying to do this and see how it works. And we know it worked in Mexico. We don't know if it's going to work anywhere. Different legal systems have different ideas and different structures. So we'll see. We'll have lots of things to learn, but we have a very encouraging first step in that direction.
Thank you, Federico, and thank you, Primavera. I think you have to leave us now, if that's correct. Great, thanks for joining, and good luck with your next session. Just a comment on that, Federico. I wanted to just sort of give some of the background of that question, which might be interesting for the discussion, and is that, I've been trying to distinguish for some time between context of discovery and context of justification, where a decision is made. And the question was really leading to what is the type of reasoning that is used for the decision. And the law works on a fiction that judges decide as they motivate, that word doesn't really exist in English, but that as they justify their decision. So in French or in Spanish, we have motivation, right? Of the decision is what the judges write in a decision, what the arbitrators write in the decision. And we assume that that's how they reason to solve the dispute. And actually we had cases which are jury trials, where it is juries that decide on a criminal case, and for a very long time, it was accepted that it was not possible to provide a justification, a motivation, to the decisions made by the juries because they were not reasoning the way legal reasoning works. And then this was considered on several occasions by the European Court of Justice and Court of Justice of the European Court of Human Rights and other courts as being a violation of due process. And in many jurisdictions, we accepted to put on top of the jury decision a justification. And I'm just saying this because of the fact that you use, in my opinion, game theory to solve a dispute. But this is a big claim, and I'm sure a lot of people will disagree. Let's see if we pick up this on the discussion. Does not mean you cannot provide a justification in law. But that's another. Just putting that as well on the discussion, and that's sort of what part of what motivated the question behind. So Federico, I think you have just still the last question to comment on. It's your turn to comment on Florence's question. This is the last comment. If you can keep it a bit short so we can have the time for Karen and for questions from the audience.
Yeah, sure. So my question is for Florence, and it's, what role should blockchain-based dispute resolution tools play in relation to access to justice? Are they likely to fill a gap that the current dispute resolution system cannot justify, or are they more prone to play a role in the context of Web3 and the metaverse? So the main answer by Florence is that the ODR are mainly used currently to solve disputes coming from the e-commerce world, and because of its ability to provide more like simpler, faster, and cheaper method. And this offers inclusion in access to justice in situations where the traditional state justice system cannot do because of, well, the cost of legal proceedings and all that we already know, right? So, and then there is lots of things that we already discussed. For example, the idea of how to resolve cases where there is a situation of anonymity of parties. For example, or what happens when one of the parties that is having the claim is a DAO, a digital cooperative for members, kind of the equivalent of a company suing someone, a case between companies. So the idea is, well, that blockchain dispute resolution systems can address this number of situations where traditional justice systems cannot be efficient or cannot be used because of metaverse situations or because just they are too expensive to use, like in small claims situations. To which I think I agree mostly. I already discussed this even in this session. I think that for me, the main question is where to draw the line. And this is something that I think we learned from experience of having more cases resolved. To me, what is also very clear is that, I sometimes get questions from arbitrators in the traditional world saying, we don't imagine Kleros will be solved. We used to solve the type of dispute we solve in oil and gas or international trade and all that. So they sometimes see Kleros like in a dismissive way in order to solve, these small claims that we don't like to solve at court because it takes too much time, or this type of things that small lawyers do. The thing is that a lot of these claims that are going to be resolved by Kleros are, as I mentioned before, some disputes that we currently don't see like disputes, and which are millions. For example, content moderation. When Elon Musk was going to buy Twitter, one of the big questions that people ask is, okay, what happens when this billionaire owns Twitter and then can start deciding who gets to say what on the platform? And this involves like fundamental rights of free speech. And moderate to discuss and what it's not. Even in the Web2 system, like company like Facebook, they try to build this what they call like Supreme Court, let's say, for external body try to solve very hard situations of free speech where some comment might be there high. So we are seeing a number of situations where processes that are seen now as internal procedures done in companies like Facebook. Well, they seem to have more stake.
I think the documentation is
just Can you hear me now? Yeah.
It's now it's better. Yeah,
it's better. So so just say, yes. Decentralized justice and blockchain is going to be used for things that are not the main business of traditional judges, but those new things, those new disputes are going to be the most important dispute that we are going to have in the future in a world where we spend more time in the metaverse and deal with digital assets and all that. So, it's small, but it's growing, and in some years it will overtake traditional courts.
Florence, a short comment on Federico's question? Or we should...
Yes, I will make it very short because I know we are running out of time. Well, I just added one point that could be useful is that well, basically the question was to wonder if there will be a system of justice in the metaverse, and we already spoke about it. But I was just doing a parallel between e-commerce. that requested a very early system of justice, of private justice, that was furnished by the ODR. And now on the blockchain, we have blockchain-based dispute resolution systems. And in both cases, these dispute resolution systems that are provided by private companies are meant to fill a gap. And it's clear that the states, in some ways, admitted that they cannot render justice in these kinds of environments. So e-commerce, because there are too many claims and there are of too small amount of money. In the blockchain-based, in the blockchain environment, it's difficult to render justice because we don't know the people, they are anonymous, and we have DAOs that do not have any legal personality, so it's difficult to judge. And now in the metaverse, it will be exactly the same problem. So there are going to be dispute resolution systems provided by private actors to fill the gap, and I'm sure about it. And I just wanted to add some points that is interesting, is that there is a Portuguese law that provides that each platform user has the right to an alternative dispute resolution system to resolve conflicts arising from legal relationships established in cyberspace. So that's some traductions that I have from this article that is in the Portuguese law. So it provides that each person that uses a platform has a right to an alternative dispute resolution system to resolve conflicts that arise from legal relationships established in cyberspace. That's very interesting, this article, because I think it's the only one that provides such a concept. And it's very interesting because in a way, we can see in this article of the Portuguese law that there is some kind of recognition from the state that it does not have the means to deliver justice in cyberspace, because the state adopts a law saying that every person has a right to have a private justice system, because clearly it cannot give justice in this environment. So I just wanted to add this for further reflections. Thank you.
Thank you, Florence. Karen, floor is yours for, let's say, 8 minutes for comments and your opinion before we move on to open up for questions.
Yeah, so thank you to all three speakers for these interesting, answering these questions in a very interesting way. Of course, decentralization in its absolute is built on a utopic vision. We're redoing the world and we're doing it better than what we have now. And we're redoing it better by using the experiences we've gained in this world to prevent any difficulties that we might have in that one. So in utopia, everything is, of course, cheap, or at least at an accessible price. Everybody involved is a rational actor who responds to a known set of incentives, and everyone follows the script, right? There are two comments on that, and two general comments also on how that relates to justice, the resolution of disputes between people. With respect to the empirical evidence, which is based on a small study that I was involved in, at the moment, the empirical evidence shows that there are some issues that get in the way of decentralized dispute resolution mechanisms taking off, and those are basically that they are not cheap at all. Because of the volatility of the price of gas, being able to have a dispute resolved on the blockchain is not something that is necessarily accessible price-wise to everybody at every moment in time. In fact, more often than not, it might even be more expensive than the value of the dispute, especially if we were to think about the small consumer claims, which it's ultimately designed for. Of course, once the market forces have figured out the price of gas and hopefully it stabilizes, and it becomes economically accessible to everybody to actually have the choice, as Primavera was emphasizing, that having the choice between the centralized dispute resolution mechanisms and the decentralized dispute resolution mechanisms can only be good for people. I mean, people can go with what they prefer, and that's always better, right? Right now, the way that because of the price being such an issue, it's not necessarily that much of a choice as we would think, where one could go from one to the other easily. Other issues to the widespread adoption of these types of dispute resolution mechanisms is that people need to know and be comfortable with cryptocurrencies, crypto tokens, blockchain, etc. And what's happening right now, obviously, and as that continues, people will maybe be more open to having their disputes resolved on blockchain hosted dispute resolution mechanisms. But ultimately, what the empirical evidence seems to indicate is that people who use decentralized justice and use platforms that have decentralized justice built in are those who are already familiar with this world, which is not necessarily the case for everybody else, and got in at a time when it was relatively cheap to enter the game. And in retrospect, maybe some of them found that the price of gas was sort of an issue, and then maybe that the disputes were not economically viable to have resolved there, or even in the case of Kleros, maybe it doesn't even make sense to serve as a jury because the financial barrier to enter is sometimes so high depending on the day. So that is an issue. Once that gets resolved, which hopefully it will, then we really have a sort of a natural experiment where we're having this new dispute resolution world being built with the direct input from the end users, as Federico discussed. Until that, we're not really quite there yet. But when it does happen, it's going to be something to see. And in some ways, it does a little bit ring the bell for the end of the professional judge in some ways, when you think about that, you know, democratic participation where anybody can sort of come and resolve the dispute of anybody, and then the Schelling point will determine what the most reasonable and best outcome is. That will naturally lead to a sort of specialization of the different types of fora, the off-chain versus on-chain enforcement fora. So we're sort of sitting here waiting for this natural experiment to work so we could see how it's going to go. And another interesting thing is that in addition to all the questions that have already been raised, of course, I'm not going to repeat them. But once the doors open and the floodgates open, and it becomes financially feasible for decentralized justice to actually be a viable option, where anybody can think, oh yeah, I could go there instead of filing a claim in court. Once that happens and we start, it's going to be really interesting to see whether in this natural experiment, we are somewhat predestined as humans to sort of reproduce the issues that we have in our current interactions with each other. So one thing that I'm thinking about is that will there inevitably be, in sort of law and society literature, a group of elites that will emerge who know how to sort of not take advantage, but like know the rules of how to how justice is going to be rendered so well in the decentralized world, where they can get favorable outcomes as repeat players, things like that.
Thank you, Karen.